So very good evening to all the participants. Today is just an introductory session and it will be more of an interactive nature. So I'll be asking questions and you have to reply. First question is, how many of you are having a copy of the Bear Code with you? Either soft copy or hard copy. Are you having a copy?
Yes,
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 sir.
yes,
Yes.
yes.
Yes,
Okay.
sir, I have.
Anybody who doesn't have a copy of the Bear Code? Either hard copy or soft copy, because you are supposed to have it. You have to refer to the sections, you have to refer to the regulations. So I think it is always better to either have a soft copy or hard copy of the Bear Code. Now, do you know what is the cutoff date for the syllabus?
It's 31st March 2023.
2023. Okay, okay. Anybody who is having a copy of, say, some later version, suppose you are having a hard copy of 24 or 25, or you are having a hard copy or soft copy of 23
Yes.
only.
Yes, sir.
Okay,
Latest version is in 24.
24. Okay, okay. So if you are having a hardbound book of 24.
Yes, sir.
Yes, yes, yes.
Okay, okay. So I think another source I will provide you is my website. So on my web, if you go to my website, let me show you my website. Just a minute. So this is my website, very easy to remember, www.carkgupta.com. So on this website itself, you will find on the left hand side an icon IBC 2016. If you click on this, you will find new Bear Code rules and regulations. And if you click on this, then you will get a PPT. So this PPT is of the Bear Code rules, regulations, circulars all at one place and updated up to 31st March 23 only. So because if you get a copy, suppose today you go to the market and you want to buy IBC Bear Code, you will get a copy of 25. Although there are not much changes, so you can ignore those changes also. But particularly if you are in the habit of reading from the computer or laptop or in a mobile, so you can download a copy. If you are in the habit of reading from text printed material only, then also you can get a printout of this through some photocopy. And I think this will be the best way to study. So this is the first thing. So from tomorrow onwards, either you will be having a soft copy of this material or hard copy of this material or any other book, whatever you are having. You know, even if you are having a copy of say 24 or 25, there are not much changes. And through the asterisks, they mention particularly the amendments which were made in 24 or 25, and then you can accordingly ignore them. But this is another source from which you can have a copy of the Bear Code, which is as per your syllabus. Okay. So this is the first thing. Now, because there are so many other laws also. So let me share with you the source for some other laws also. So how many of you do you have a copy of the Companies Act? Do you have a copy of the Companies Act? Or say other Bear Acts? So how you are reading about those other laws? Anybody?
Yes, sir, I have the copy of Companies Act.
Okay. Anybody else?
Yes, sir. Yes, sir.
Okay, okay.
Yes, sir. I also have the copy.
Okay, okay, okay. Great.
Sir, I also have a copy. Mohini.
Okay, okay, okay. So, but another source of this is my website. I'll show you my website. Let me just show you. Now, suppose you want to have a copy of the Companies Act. So on my website, you will go to this Knowledge Bank, and through Knowledge Bank, you will go to Acts. And in Acts, you go to Corporate Laws. So in Corporate Laws, you go to Companies Act and you will get a copy of the Companies Act, chapter wise. Because all the chapters are not in our syllabus. So you have to read particular chapters only. And The beauty of this soft copy is that you will get a copy of the relevant rules also. So in a particular act, in Companies Act, suppose something is prescribed and then you click on the word prescribed, you will directly go to that relevant rule. So this is another source of getting a soft copy of almost all the allied laws which are in our syllabus. Suppose you want to have a copy of FEMA, you want to have a copy of say PF Act or LLP, Partnership Act, Contract Act. So you will get all the copies here. Most of the Bear Acts you will find at the home page only. On home page, on the left hand side, you click on IBC 2016 and you will get a copy. Prevention of Corruption Act, Micro, Small and Medium Enterprises, Real Estate Act, Securities Contract Act, Surface Act. So you can have a copy from here itself. So you can make use of this, and if you have got a hard copy, nothing like it. If you want to learn from soft copy, this is another source which is available with you. You can refer it to others also, and we don't ask anything from anybody who is downloading any material from our website. And this is the reason there are more than 6 lakhs views on my website till today. More like 170,000 views on my YouTube channel. Although my YouTube channel is mainly restricted to paid students only. If I open it for everybody, it may have 10 lakh views. But for the present, I am restricting it to my paid students only, most of them. Some of them are freely available to others also. But most of the latest videos, they are available to the students who are paid students. And that is on the insistence of my students only that, okay, you restrict it to those who are paying you fees. Otherwise, we will also not pay you if you make it free for everybody. So now I'll ask you some questions about IBC to have an idea as to how much you know about IBC. Any idea about what is this BLRC? What is this BLRC? Any idea? You can unmute yourself, Sudhirji.
It was a banking law regulation committee.
This is actually Bankruptcy Law Reforms Committee. And they may ask you a question also on this. It may be a 1-mark question. Bankruptcy Law Reforms Committee. And who was the chairman of this committee? Mr. T.K. Vishwanathan. They may ask you a question. Bankruptcy Law Reforms Committee. And this committee had the mandate of a comprehensive reform to rewrite the various laws. So, because there were earlier laws also, so like SICA was there, RDB was there, SURFACE was there were so many laws and they were handled by different courts. So this winding up, they were being handled by high courts. But now, through this committee, through the recommendations of this committee, which gave its report in 2 volumes, one was the recommendations and the second volume was the draft IBC code, and most of the recommendations were reproduced as it is in the insolvency and bankruptcy code. So T.K. Vishwanathan was the chairman and it is Bankruptcy Law Reforms Committee. They may ask you a question on this. So it's very important. If you get time, you please try to read the major recommendations. Although we'll also be covering most of them here. But if you get a time, because there are, as a student, you may be having different times available with you. Some of you might be free the whole day. So if you are in the habit of reading, you can read from the this Bankruptcy Law Reforms Committee also, which is in 2 volumes, volume 1 and volume 2. And I would request some of you to please post in the group the BLRC report itself. So this is the first thing. Now, second thing, this law IBC is based on which law? Whether it is based on UK law or it is based on US law. And what is the difference?
It is based on UK law, sir.
UK law. Right. And what is the difference between UK law and US law? Because if you read various IBC provisions, then almost every country has got their own laws on insolvency. Like Malaysia has got their own law, Australia has got their own law, Canada has got their own law, but most of them, they are drawing their basic inferences from these two laws only, UK and US. And the basic difference between these two is that the UK law shifts the control from the management to the creditor, to the financial creditor. Basically, this is the basic difference. In case of US law, they allow the promoters to retain control despite the default, as was in the earlier case. Because in Companies Act, if you see, when this IBC was not introduced, then the promoters used to stay in control despite default. But this UK law is based on the premise that if the existing management is not able to perform, then let the control shift from the management to the financial creditors. Because they say that the financial creditors are the one who have provided financial muscle to the company. They are the persons who have invested in the company. And so UK law and US law. This is another important concept which you must remember. Another thing is that there are two types of creditors basically, financial creditors and operational creditors. So who are given precedence in IBC and why? In IBC, who are given precedence, whether financial creditors or operational creditors, and why?
Financial
Yes.
creditors.
Yes, financial creditors. And why they are given precedence? Why they are giving importance?
So because mainly they are lenders, financial institutions.
Yes, because they are the one who are almost equal to the owners and sometimes more important than the owners. If you see the financing of a project, then the promoter's contribution is 20-25%. But rest of them, from whom they are coming, from whom this contribution is coming, basically from financial institutions or financial creditors. So financial creditors are the one who are attached with the company from day one. And sometimes they are more important than the management itself. Sometimes if the promoters are dishonest, so what they will do, they will take out even their 20-25%. So they will just reroute the funds and they will take out even their initial contribution, and they will be just say exploiting the money which is being provided by the financial creditors. Most of them are banks or financial. So they are playing on the money of banks or financial institutions. So this is the reason why in IBC they are giving an importance to financial creditors. Another important concept here to remember is what is the position of home buyers in IBC? Home buyers, whether they are financial creditors or operational creditors, and why?
So they start themselves with a operation creditor, but now there is a financial. Now this is they are also financial creditors.
Yes, actually, when IBC came, there was a lot of confusion whether home
Yes.
buyers are financial creditors or operational creditors, because they were neither considered as financial creditors nor operational creditors.
Yes.
The argument given was that they have not provided finance to the company. So they are not financial creditors. They have
Yes.
neither supplied goods nor services to the company.
Yes.
So
Yes.
they are
Yes.
not operational creditors. But then the Supreme Court clarified that these home buyers are the foundation for the builder projects. So basically, builders are playing on the money which is given by the home buyers. So they are providing finance, they are providing the financial muscle. Sometimes builders are not investing even single rupee. On paper, they may be investing, but they are taking the money from home buyers and they are building the projects. So that is why they were considered as financial creditors. So home buyers are considered as financial creditors. Another important question is whether a single home buyer can initiate this insolvency process, or there has to be a particular number or particular percentage of home buyers if they want to initiate insolvency process.
The 10% of the total number of home buyers or 100, whichever is lower.
Yes. Actually, when IBC came, the default amount also was 1 lakh only. And at that time, there was no concept of this 10% or 100. So what happened? Even a single home buyer was initiating insolvency proceedings. And then the builders lobby, they resisted it. They said that, okay, they are just manipulating us. They are bringing the whole project to a halt. Even if there is a slight default in a particular case, all the rest of the home buyers, they are satisfied with our project. But a single home buyer is just manipulating the whole thing. So they said that, okay, let there be a specific number or a specific percentage of the real estate project, those who can initiate insolvency proceedings. So this is another concept which is important. Another point is regarding operational creditors. Who are operational creditors? Any idea?
Who have
Doing business
supplied
with them?
either
Yes.
who have supplied either the goods or services to the debtor.
Okay. Any other person who can come under operational creditors besides these?
The government authorities.
Yes. So all the government dues, whether they are related to income tax or GST, customs, excise, all these are covered under operational creditors. Any other category which can come under operational creditors apart from these two? Yes, Sabir Rafael ji, any idea?
Yeah, whether employee can be the operational.
Yes. Employees and these
Consultants?
workmen. Yes. So whether professionals will also be covered under
Yes.
operational creditor?
Yes.
Yes. So professionals will also be covered under operational creditors because they are providing services to the company. And suppose there is a person who has given loan also and is providing services also, then how he will be covered? There is a person who has given a loan also and he has given services also, then how he will be covered?
Sir, for the amount of loan, he is a financial creditor. For the purpose of is a operation creditor.
Yes, very correct. So, whatever is the amount of loan he has given to the company, financial assistance, to that extent, he is a financial creditor. And to the extent he has provided goods or services, he is an operational creditor. Another important concept, whether assignment of debt is possible in insolvency. Suppose you are an operational creditor, whether you can assign your debt to a financial creditor, whether it is possible or not.
No.
It is possible.
Okay.
Assignment is possible because assignment is governed by law. So anybody can assign his debt to the other person. If you are an operational creditor,
Operational. You are
but
talking
it
about
will not change the character.
Hmm.
Suppose you are an operational creditor and
Okay.
you have assigned your debt to a bank, but still that bank will be an operational creditor to that extent.
Okay.
That is the basic concept. So, just by assigning, you cannot change the character. But assignment is possible even during insolvency. So, these are some of the basic things about insolvency which you must know. Now, let me share my presentation with you. Okay. I hope my screen is visible.
Yes, sir.
Okay. So any idea what is the difference between this insolvency and bankruptcy? And whether a company could be declared bankrupt or not? In case, whether you can say that, okay, a company is into bankruptcy or bankruptcy you cannot use for company. What is your idea of this?
The bankruptcy may involve the insolvency because before bankruptcy there should be insolvency, then the bankruptcy may come. But insolvency may not have the bankruptcy.
No, that is true. But whether we can say that a company has become bankrupt or we cannot say so.
Yes, sir, the company can be bankrupt.
Actually, the concept of bankruptcy is associated with non-corporate entities only.
Yes.
Okay.
So, the word bankruptcy is associated with
With
individuals, partnership firms, and other non-corporate entities. Why? There is a reason. The corporate entities, they have got a legal existence on their own, and there can be dissolution only. There can be liquidation only. So first of all, we will try to resolve the insolvency, and if that is not possible, then liquidation. And after liquidation, dissolution. Whether there has to be dissolution of a company in every case, or there can be some other course also in IBC. Suppose a company is into insolvency, we could not find any resolution applicant, so insolvency was not possible. So now the company has entered into liquidation phase. Now my question is whether every company who has entered into a liquidation phase need to be necessarily dissolved or not? This is my question.
No, sir.
Acha, what is the other alternative?
Sir, the new management can take over the company and they can run it
Yes. So
like they have
even
done in
during
Yes Bank.
liquidation, it may be sold as a going concern. So in that case, that process will be called the closure of the liquidation process. So in that case, there will be no dissolution, but liquidation will be there. But after the liquidation, the new management will take over because that company will be sold as a going concern to some other.
management.
Now BLRC. Let us discuss briefly the Bankruptcy Law Reforms Committee. ठीक है, अब ये तो याद रहेगा ना, इसका देखिए फुल फॉर्म याद रहना चाहिए. दे समटाइम्स आस्क द क्वेश्चन, वो बोल देगा आपको बैंक्रप्सी लॉ रिफॉर्म्स कमेटी, बैंकिंग लॉ रिफॉर्म्स कमेटी, बैंकिंग लॉ रेगुलेशंस कमेटी. ये बहुत सिंपल बात है, एक नंबर तो आपका इसी पे आ सकता है, बैंक्रप्सी लॉ रिफॉर्म्स कमेटी. ठीक है. सो देयर इज ए टाइम बाउंड मैकेनिज्म फॉर रेजोल्यूशन. व्हाट इज द मीनिंग ऑफ दिस टाइम बाउंड रेजोल्यूशन? क्या मतलब है इसका? Beena ji, please tell me, what is this time bound mechanism for resolution? Beena ji, are you there? भाई देखो, सभी लोग अपने वीडियोस ऑन कर ले चाहिए पहली बात तो, क्योंकि देखिए वी हैव टू बी वेरी सीरियस. ऐसा नहीं है कोई यहाँ पिक्चर चल रही है भाई, कभी आ गए कभी चले गए, तो उससे कोई फायदा खास होने वाला है नहीं, है कि नहीं? हम सीरियसली पढ़ेंगे तो फिर रिजल्ट्स भी अच्छे आएंगे हमारे. अगर सीरियसली नहीं पढ़ेंगे तो फिर रिजल्ट कहाँ से आएंगे? मुश्किल हो जाएगा. मनु जी, एनी आइडिया अबाउट व्हाई व्हाट इज दिस टाइम बाउंड रेजोल्यूशन? टाइम बाउंड मैकेनिज्म का क्या मतलब है?
So time bound mechanism का ये है कि there should be a system in place in which the resolution proceedings should take place and it should be completed in some time bound manner, like say within a period of 6 months or in a year.
Right. So time bound mechanism in IBC stands for a period of 180 days in case of corporate insolvency. So whenever you are appointed as an IRP, you have to plan your affairs in such a manner that everything is completed by 180th day. Although there is a provision for extension, but the planning initially has to be according to 180 days. And whenever there is a delay, you have to account for each day of delay. And whether there is a concept of working days or holidays here, whether it is 180 days, 180 working days or 180 days.
The total 180 days, including the holidays.
Yes. So if the time has begun to run, it will stop at 180th day only. So T plus 180, whether it is holiday or so, the time once it begins to run, then it will stop on 180th day. And you have to plan your affairs in such a way. There is a regulation 40A which prescribes the timelines. So I will request each of you to please go through those timelines also during the daytime whenever you find time. So 180 days initially you have to plan. And what is the extension which is allowed? Maximum period of extension allowed?
Initially 90 days.
Yes.
And overall 330 days.
Yes. Initially 90 days, and that too at the discretion of the adjudicating authority. Actually, suppose the COC, they have to apply for extension for maximum period of 90 days. But if they say, if they want extension for 90 days, then the adjudicating authority also has to be satisfied that such time extension is necessary. They may allow 45 days, though every extension may not be sanctioned by the adjudicating authority. So it's a time bound mechanism, and every day of delay has to be satisfactorily accounted for. And there is a provision for filing of forms also. Suppose any activity is not completed within a particular time frame, then you have to file forms also for each day of delay within 3 days and every month thereafter. Suppose a public announcement has to be made immediately or within 3 days, and if you are not able to make the public announcement, then you have to fill up a particular form that okay, this activity was not completed. And every month thereafter, you have to fill up this form. CIRP 7, I think, is the form which we will study. So, time bound mechanism. Creative value destruction. What is this creative value destruction? Because there is destruction with the passage of time. Suppose there is a project. Now that project has run into rough weather. Suppose the decision to resolve that thing takes too much time, then there will be loss in value, because say the plant may get rusted. You might have seen factories which are lying as it is for years together. So there is a reduction in value, diminution in value. But this BLR, this insolvency BLRC report, they suggested for creative value destruction. Why this creative value destruction? Because they presume that there could be a diminution in value. There could be a reduction in value, but it should be creative. Why creative? Because if you are able to resolve the financial problem within a particular time frame, then there will be lower value diminution. So that is why they stressed on this concept of creative value destruction. Unleashing higher levels of debt financing across a wide variety of debt instrument. What is this concept? Any idea? Manu Gupta ji? Any idea what is this unleashing higher levels of debt financing across a wide variety of debt instruments?
No, sir. No idea.
Actually, because whenever a company has come into insolvency, so that means there is some problem with the finances of that company. When we are finding a new buyer, so that means they will be infusing funds into that company. Sometimes what they do, they convert the equity also into debt. They convert the debt into equity. So,
Okay.
and sometimes they introduce new finances also to the company. So this BLRC report said that this through the mechanism which we are suggesting, it will unleash higher levels of debt finance.
Debt financing. Okay, sir.
Because the promoters, the new promoters who are coming, they may introduce a wide variety of debt instrument. They may say that, okay, you take these convertible debentures. We will convert them automatically after a particular time frame into equity and all those things. So they suggest different ways of financing. Facilitating the assessment of viability of the enterprise at a very early stage.
Okay.
So naturally they see that, okay, whether this is viable or not. In case it is not viable, then let us go for early liquidation. Enable symmetry of information between creditors and debtors. So they said there is no symmetry of information between creditors and debtors. So they introduced the concept of this information utility. So this information utility there, so they say the bankers, they will be providing information on a periodic basis. What are the loans given? What are the charges created? What are the charges satisfied? So all this information will be available both to the debtors and creditors through a system of information utility. There is only one information utility as of today, and that is National E-Governance Services Limited, NESL. So this NESL, they are providing information to the creditors, to the debtors and public at large on payment of certain fees. So you can give information and you can get information from this NESL. Next is ensure a time-bound process to better preserve economic value. So this time-bound process will help in preservation of the economic value. There will be less of a value diminution. Ensure a collective process. So they are saying that let a collective body, this collective body is the committee of creditors, and it basically comprises of financial creditors. So another question here, whether all the financial creditors are allowed to take part or only related or unrelated financial creditors.
Only the unrelated financial creditors.
Yes. What is the reason?
Because of the related party, they may have some influence in the decision of the taken.
Right. Because the decision has to be unbiased. And if they are related parties, they may favor the corporate debtor. This related party is in relation to the corporate debtor. So if they are related party of the corporate debtor, so they are considered a part of the management only. And we want to shift the control of the management from the debtor to the creditors. So that objective may not be achieved if we allow the related parties to take part in the decision-making process. But whether they are allowed to attend the meetings or they are not allowed at all.
They are allowed to attend the meetings.
Yes, very good. And whether a related party can file an application for insolvency or related party is not allowed to file an application for insolvency.
Related party is not allowed to file.
Related party is allowed to file. Because if you have given loan, if you have given financial assistance, simply because you are a related party, because first of all, loan has to be proved. It has to be proved naturally that you have given a loan. Adjudicating authority will definitely satisfy themselves. You will also give proof that, okay, I have given a loan. Suppose I have given a loan to my brother. Now, whether I am not allowed to recover it, my brother is not paying me back, then whether court will say that, okay, because he is your brother, so you are not allowed to file an application? The answer is no. So even if you are a related party, you can file a petition for insolvency. You can file an application under Section 7. But you will not be a part of the decision-making body. You will be not allowed to become a member of the committee of creditors. So this distinction we have to remember. So simply because we are a related party, it's not that we cannot initiate this process. We can initiate, but we will not become a member of the COC. Similarly, if you have supplied goods or services, whether you can initiate this process of insolvency?
Yes.
Yes. But whether you will come to the committee of creditors or not?
No.
No. So, if you are an operational creditor, you can initiate this process of insolvency against the company who is not paying up. But you will not be allowed to become a member of the committee of creditors. Whether there is any chance that you will become a member of the committee of creditors in any situation, can you think of any situation where these operational creditors, they will also become a part of the committee of creditors?
Yes.
Yes.
Something is possible.
In what is the situation?
In home buyer's case.
No, home buyers are financial creditors only. I am talking of operational creditors. So operational creditors, whether they can come to the committee of creditors, can you think of any situation? Acha, let me put it in another way. There are no financial creditors in the company. It is a debt-free company. In that situation, who will come to the committee of creditors?
First 18 operational creditors.
Yes. And whether it is by number or it is in terms of value.
Value, sir.
Yes. So first 18 operational creditors in terms of value plus one representative of workmen plus one representative of employees. So they will constitute the committee of creditors. Another situation. There are financial creditors, but still operational creditors will be invited to the committee of creditors. What is that situation? There are financial creditors also, but still operational creditors, they will also be invited to attend the meetings of committee of creditors. Can you elaborate on that situation? What is that situation?
So
Yes, Samir Rafaelji?
Yeah, proportionately the financial creditors may be less.
No. Actually, it is dependent upon the quantum of the operational creditors. So if the operational creditors are substantial, if the operational creditors constitute not less than 10% of the total debt, in that situation, one representative of operational creditors will be invited to the meeting of committee of creditors. Although they will not be entitled to participate, they will not be entitled to vote, but they will be entitled to attend the meeting of committee of creditors.
Once, can you repeat, sir?
Yes, actually, if let us take two situations. First situation is there are financial creditors. So normally financial creditors, the unrelated financial creditors will constitute the committee of creditors. But if operational creditors, they comprise a substantial portion, that means not less than 10% of the debt. So in that situation, they will also be invited to the committee of creditors. Only one representative.
So, sir, in the case when there are no financial creditors and only
Yes.
operational creditors are there,
Yes.
so what will happen then? So
They
will
will, they will constitute the committee, 18 largest operational credit, and the provisions
they,
will apply as it is as in case of financial creditors. So they will be the
okay,
decision making because there are no financial creditors.
okay, sir. Okay.
So 18 largest operational creditors in terms of value plus one representative of workmen and plus one representative of employees. So they will constitute the committee.
So it means committee of creditors only include financial creditors.
Yes, normally. Normally, the
And
committee
and
of
and,
creditors will
and
include
if
only the unrelated financial creditors.
and if there is operational creditors representative and one employee representative, then it cannot vote.
No. In any case, they cannot vote. Only the unrelated financial creditors will be
Have the
allowed
right to vote.
to take part in the proceedings. They will be allowed to participate. They will be allowed to vote.
Whole
So
100% belong to
I
financial
will,
creditors.
let us briefly summarize the three situations. First
Yes.
situation is there are financial creditors and there are operational creditors, which is the most possible situation.
Yes, sir.
And the operational creditors, they are less than 10% of the total debt.
Correct, sir.
In that situation, only unrelated financial creditors will constitute the committee of creditors. Second situation, there are financial creditors and there are operational creditors. But operational creditors constitute not less than 10% of the total debt. In that situation, one representative of operational creditors will be invited to attend the meetings of committee of creditors, but they will not have any right of participation or voting. Third situation, there are no financial creditors, only operational creditors. So then in that situation, 18 largest operational creditors in terms of value plus one representative of workmen plus one representative of employees will constitute the COC. So these are the three situations. I hope
I'm
now
sorry,
it is clear.
I'm sorry, sir. Third point, can you please repeat it again? Third point.
Third point is there are no financial creditors. It is a
Yes.
debt-free company. There
Hmm.
are only operational creditors.
Hmm.
So in that case, of 18 largest operational creditors in terms of value, plus one representative of workmen, plus one representative of employees will constitute the COC.
Sir, what is the difference between workman and this employee?
The workman has got a specific definition which is given in section 3. Workmen are basically, the definition of workmen is as per the Industrial Disputes Act. And basically, the persons who are in armed forces or in police or employees of prison, they are not considered as workmen. And everybody who is not a workman is an employee. So workmen are given precedence in case of payment, in liquidation, or in case of resolution plan also. So that is why there is a distinction between workmen and employees. So there is a specific definition which we will study. So respect the rights of all creditors equally, value maximization. And outcome of bankruptcy must be binding on when negotiations fails to establish. And there is a clarity of priority. Just a minute. Rights of all stakeholders are upheld in resolving bankruptcy. Now BLRC report. So as I already told you, there are two volumes. Volume 1 is text of the findings and recommendations, and volume 2 is draft insolvency and bankruptcy bill. Now, who will volunteer to post this BLRC report in the group? Anybody who will volunteer? Okay, will post it in the group today.
What should we post, sir?
You should post the BLRC report, Bankruptcy Law Reforms Committee report.
I will do it, sir.
Okay. Oh, great. So it is in two volumes, and this was under the chairmanship of T.K. Vishwanathan ji, and it started in 2014, just to see the pace. So BLRC, Bankruptcy Law Reforms Committee, formed under the chairmanship of T.K. Vishwanathan, and then they submit its interim report in February, and it had the mandate of a comprehensive reform. Then Ministry of Finance invited public comments, Volume 1, code introduced in Parliament, referred to JPC, Joint Committee invited comments, bankruptcy code passed by Lok Sabha, Rajya Sabha, and received President's assent. Just to see the pace of events, so it was very quick. Summary. There is a concept of insolvency regulator. So who is this regulator? The regulator here is the Insolvency and Bankruptcy Board of India. So Insolvency and Bankruptcy Board of India is the regulator, which is an independent body. It has got its own existence. It can sue and it can be sued. It has got common seal, just like a company. So it is a regulator. It's an autonomous body. So central government, by way of a notification, they made this IBBI as the regulator, Insolvency and Bankruptcy Board of India. And I would request each of you to go through the website of Insolvency and Bankruptcy Board of India, ibbi.gov.in. Why? Because they are publishing their reports also. So, and sometimes questions come through these reports. So try to go through the reports, and sometimes they give very beautiful charts also on the various processes. So you should, as a student, you should go on visiting. You should keep visiting the website of ibbi.gov.in whenever you find time, because it may help you in examination also. Sometimes they just put brief of the cases, case laws also, important case laws also. So that also helps in understanding IBC. Then insolvency adjudicating authority. So there is a concept of adjudicating authority here as compared to the concept of courts. So here there is a concept of adjudicating authority, and adjudicating authority for corporate persons is NCLT, National Company Law Tribunal. Yes. And then appellate authorities, National Company Law Appellate. Similarly, for individuals and partnership firms and other non-corporate entities, the adjudicating authority is Debt Recovery Tribunal, and the appellate authority is Debt Recovery Appellate Tribunal. Yes. The role of high courts is bare minimum, just to ensure non-violation of our fundamental rights. Because you can approach High Court also in case there is any violation of your fundamental rights. So normally High Courts and Supreme Courts are directly being approached by filing writs. Then there is a concept of bankruptcy and insolvency information utilities. As I told you, there is only one information utility as of now, bankruptcy law National E-Governance Services Limited, NESL. And you must visit their website also, NESL. So you will get an idea, and you should try to register yourself also there. So it will give you an idea as to how it operates. So they are providing information about companies on payment of a particular fees. So you just register yourself there on the website of NESL by uploading certain documents, and you can then access it. Then insolvency professionals, individuals and entities. So you can practice either as an individual or as an entity. Suppose you are a chartered accountant. Then you can either practice as an individual or you can form a firm. So similarly is the concept here. As an insolvency professional, you can practice as an individual or you can form an insolvency professional entity. Sometimes people ask whether if I am practicing as a chartered accountant, whether I can simultaneously practice as an insolvency professional. The answer is yes, but you have to have a separate letterhead, you have to have a separate constitution, you have to have a separate bank account. Because the receipts which you are getting, on that also you have to pay a prescribed percentage of fees to the IBBI. So for that purpose, for keeping separate accounts, for separate records, you need to have a separate bank account, separate letterhead, separate stationery for this practice. But there is no bar. Another important question which sometimes students ask is, I am in a job, so whether I can become an insolvency professional? The answer is yes. There is a concept of authorization for assignment. Like in practice, we have got a concept of certificate of practice. Suppose we are a chartered accountant, then there is a concept of certificate of practice. Similarly, here there is a concept of authorization for assignment. So you can become an insolvency professional and you may not apply for authorization for assignment. But if you want to apply for authorization for assignment, then you need to leave your job. So this is the basic thing. So you can become an insolvency professional and still not practice it as such. Sometimes what people do is, suppose you are a chartered accountant, you may not be interested in getting certificate of practice, but still you can give some consulting. So you can become a consultant if you have got the knowledge of IBC, then you can become a consultant. You need not become an insolvency professional. You need not become an IRP or RP or liquidator, but still you can give advice to companies which are into this insolvency.
Sir, one question.
Yes, yes.
Once I qualify this exam to apply
Yeah.
for membership, do I need to leave my job and take practice, or I'll get membership in employment also?
You will get.
Hmm.
You will get membership, but if you are applying for authorization for assignment, then you should be,
Leave the job.
you have to leave the job. Yes. Then to revamp bankruptcy and insolvency processes for companies and partnership firm, fast track insolvency resolution process. In companies also, there are basically three types of processes. First is the normal CIRP, wherein we try to resolve the insolvency of a particular company or LLP which is into financial trouble. We want to explore the possibility of a new promoter, a new resolution applicant. Normal CIRP. Second is fast track. Fast track is limited to certain type of companies, say small companies or startups or companies with an asset size of not more than 1 crore. So these are the three conditions for fast track insolvency resolution process. So normal and then fast track, and then there is a process of insolvency resolution for corporate MSMEs also. So that is pre-pack insolvency resolution process. So basically there are three types of resolutions which are possible for corporates. One is normal CIRP, another is fast track insolvency resolution process, and third is pre-pack
Pre-pack.
insolvency resolution. So what is the difference between these two? Because fast track and normal CIRP, they are more or less the same, except that the time is less in case of fast track. It is just the half. As against 180 days, this is 90 days. As against the extension of 90 days, here the extension is for 45 days. But other things are almost similar. But this pre-pack insolvency resolution process, which is restricted only to corporate MSMEs. This is slightly different because in pre-pack, the control does not shift in normal circumstances. In normal CIRP, control will shift to the committee of creditors. But in case of pre-pack insolvency resolution process, the existing management will continue to stay in control. The reason is not many people may be interested in these MSMEs because the technology is known basically to the promoters. It's a small sized company. Not many people may be interested in those companies. So they say, let the existing management stay there. Although there is a concept of committee of creditors also in case of pre-pack, there is a concept. But the existing management continues to stay in control. So they are responsible for this normal compliances. Like in case of normal CIRP, even the compliance burden will shift to the IRP or RP or liquidator. But in case of pre-pack, the normal compliances like filing returns, etc., so they will be still with the existing management. The RP will act as the monitor in case of pre-pack insolvency resolution process. So he will be basically monitoring that whatever the management is doing is okay or not. There is a concept of committee of creditors also, but they say that let the existing promoter in case of corporate MSME let them put the base resolution plan. You must have heard the concept of one-time settlement. Suppose a person is not able to pay, then the bankers they say that okay, you please tell us what is the amount you want to share. Say he will say that okay, I can give only 60% of whatever is due, and the bankers may agree or they may not agree. So this is something similar to that concept of one-time settlement. So they allow the existing promoters to put a base resolution plan. And that base resolution plan, if it does not compromise on the interest of operational creditors, because operational creditors are nowhere entering the decision making process in this entire insolvency. So they say that you take care of the operational creditors, you please ensure that there is no haircut to them, and then we will allow you to put forth the base resolution plan. And if it is agreed to by the committee of creditors, then there may be resolution. Otherwise, they will invite more resolution plans. Another important concept here is that because most of the time we have been hearing that operational creditors they will not enter into the decision making process. Then how their interests are ensured? How their interests are protected in IBC? Any idea on this? Because we have always read that operational creditors they will not enter into the decision making process even if there is only a single financial creditor. So that single financial creditor alone will constitute the COC. But how the interests of operational creditors are ensured? Anyone?
Through the waterfall mechanism.
Waterfall mechanism, Sudhirji, is applicable only in case of liquidation.
Okay.
But in case of resolution, how their interests are ensured? Yes, Sabir Rafaelji.
No idea, sir.
Actually, the answer to this lies in section 30. So section 30 gives you an answer to this. Section 30 says that the operational creditors, since they are not entering into the decision making process, so they should at least be ensured of the liquidation value. Because whenever this process starts, this IRP or RP, they appoint two registered valuers. They appoint two registered valuers, and those registered valuers they give them the fair value and liquidation value. So this fair value and liquidation value acts as a yardstick to measure the resolution plans which are coming. Because if something is being offered by the new promoter, who is called the resolution applicant in this process, so in such a case, the IRP or RP will weigh it against the liquidation value or fair value. If the new resolution applicant is offering something less than the liquidation value, then the COC will decide, let the company liquidate. So they will go in for liquidation. So why they will agree for something less than the liquidation value? This is the idea. So section 30 says that if a resolution plan is coming, then the RP will ensure that the operational creditors who did not take part in the decision making process, they get at least the liquidation value or the value they would have got in case the liquidation would have happened. Although this is a supposition only, because at that stage liquidation is not taking place, only resolution is taking place under section 30. But the at least you should have something to measure against now, because they did not take part in the decision making process, so they should get at least the liquidation value. So I'll give you an example to prove this. Suppose you have got an old fridge with you. Now that old refrigerator you want to sell, you want to get rid of that refrigerator. Now there are two things: either you will sell it as it is, okay, so that the other person can make use of it. So the other person will say that, okay, I will give you 20,000 for this refrigerator, which is an old one. So I'll get it repaired and you make use of it. So this is one thing. So that person who has come to buy your refrigerator, you can equate to a resolution applicant. Now suppose a scrap dealer comes. So scrap dealer says that, okay, I will give you 10,000 rupees because I'll break it into pieces and I'll make use of whatever is relevant to me, say compressor or other things. So now you have got two parties. One is the person who wants to make use of your refrigerator. Second, the scrap dealer who wants to break it into pieces. So you can say that process is liquidation process and the first process is the resolution. So now you have got two things. So first of all, you will not give your refrigerator to the person who wants to make use of it unless he gives you at least the liquidation value, unless the value which the scrap dealer is offering to you. So you will try to get the best deal, and you will, because you have got special love and affection for your refrigerator, so you will try that if it is better if I give it to my maid so that he can make use of that. So that is the concept. So that is the concept behind resolution and liquidation. Because the resolution, if it takes place, it will take care of the employees also. Suppose you sell it as a going concern, so then the employees will also be retained in the business. So the concept of going concern is beneficial for all. It is a win-win situation for all. So we always try to go in for a going concern concept. But if that is not possible, if liquidation is inevitable, then we will try to ensure that at least we get the liquidation value. So liquidation value is with us through the registered valuers concept, which we do not disclose it to anyone. We do not disclose it to the resolution applicant also. We allow him to give his quote. But at the back of our mind, we are having a value against which we will be measuring his offer. So this is the concept. So at least the liquidation value or the value which the operational creditors would have got in case the company would have been liquidated, that is the value which the operational creditors must get. Second concept is because this resolution also is subject to approval by a certain percentage. So what is that percentage? Any idea? Supriya ji?
66%, sir.
66%. Yes, very correct. So 66% means that there are another 34% who were against this decision. Suppose 70% approve this. 70% of unrelated financial creditors approve this resolution plan. That means there are another 30 who were against this. So what is the option which is given to those dissenting financial creditors because they were not in favor of a resolution. That means they were in favor of liquidation. So similarly, they also should get at least the liquidation value. So section 30, if we read, section 30 says that the operational creditors and the dissenting financial creditors who did not vote in favor of the resolution plan, they should get at least the liquidation value. So this is the basic concept. So it means it will ensure fair treatment to all. Because if you are voting against a resolution plan, that means you are in favor of liquidation. So in case of liquidation, what you will get? You will get the liquidation value. So we are ensuring the liquidation value to you. And in case of liquidation also, whether the workmen or employees, whether they are given some preference or all operational creditors are at an equal value.
All operational creditors are equal value.
No.
No, the worksmen and employees have given a
Yes. Because I would like you, Supriya ji, to go through section 53. So section 53 says that first of all, insolvency resolution process cost and liquidation cost has to be paid, which is basically the fees of the RP or IRP or liquidator or the cost of the process involved. Secondly, secured creditors and 24 months dues of workmen. So they are given preference. And then 12 months dues to the employees. So that means even amongst the operational creditors, there is a distinction. So they are making a distinction between workmen and employees. First of all, workmen, then employees, and then other operational creditors. Similarly, as I told you about section 30, in section 30 also, this aspect has to be considered. So whenever you will evaluate the resolution plan, because the workmen will get something different in case of liquidation, employees will get something different, and other operational creditors will get something different. So whenever you want to assess the resolution plan, at that time also you will assess what the workmen will get, what the employees will get, and what other operational creditors will get in case there is a liquidation. Although liquidation is not taking place, it is a hypothetical situation. But you have to imagine because you have got the liquidation value with you. At the start itself, within 7 days of the appointment of the RP or maximum within 47 days, he will get two values from the registered valuer, fair value and liquidation value. So that value is already available. So on that, based on that liquidation value, he can assess what the operational creditors will get. And out of operational creditors also, there are three categories, as I told you. Employees, workmen, others. ये concept clear है सुप्रिया जी? Now it is clear?
Yes, sir.
सुप्रिया जी?
Yes, sir. Yes, sir.
Okay. So I tried to give you an overview of IBC today, basically, what are the various processes involved and how it goes on. Now, what were the recommendations of that committee? So the recommendations of that committee was it empowers all creditors, whether secured, unsecured, domestic, international, financial, or operational, to trigger resolution processes. So my one question here is, there is a foreign national. There is a foreign national who has supplied goods to an Indian company. So whether he can initiate this insolvency process or is not allowed?
Allowed.
He is
Yes.
also allowed. Yes, he is also allowed. And whether there is a distinction between secured and unsecured creditors. There is a difference in treatment or both are treated equally. In IBC, whether the secured financial creditors, first question, whether only financial creditors could be secured or unsecured or whether operational creditors can also be secured or unsecured. This is the first question.
Operational
creditors can
creditors
also be.
also can be secured and unsecured.
Yes. So whether it is financial creditors or whether it is operational creditors, both can be secured or unsecured. Can you give me an example of an operational creditor being a secured creditor? Operational creditor being a secured creditor. Can you give me any example? The example is
government use.
the example is a supplier,
Government.
supplier of goods. You have asked him to supply certain equipments, but he asks you, what is the security, what is the surety that you will take the goods? Tomorrow you may refuse. So what I am having, you give me some sort of security. So he will become a secured creditor.
The government also, sometimes like in GST registration, they have a banner
Yes,
code
yes,
where
government also,
in
if the particular act like Gujarat VAT Act, so Gujarat VAT Act says that okay, in case the dealer doesn't pay, then the VAT authorities will have a first charge. So it could be by operation of law, it could be by say by virtue of some agreement. So it empowers all creditors, secured, unsecured, domestic, international. It enables the resolution processes to start at the earliest sign of financial
distress.
stress. So, any idea on this? There is a concept of default here. So they say whenever there is a default is given in section 4 for corporates. So they say whenever there is a default, this process can be triggered. But here also there is a distinction between financial creditors and operational creditors. In case of operational creditors, they say even if there is a default, the process may not be triggered in certain cases. So Supriya ji, can you tell me what are the cases in which there is a default but still the operational creditors cannot trigger the process?
When the amount is less than 1 crore.
No, amount is also more. Then also they cannot trigger.
If they don't serve demand notice.
Yes. The point here is that operational creditors, if there is a dispute between the parties, then they cannot trigger this process because it is not a recovery mechanism. It is a beneficial legislation for the corporates. It is to benefit the corporates to come out of the financial stress. It is not to benefit the persons who are interested in recovering their money. Let them go to courts. Suppose there is a dispute, there is an operational creditor and there is a dispute, then he cannot initiate insolvency resolution process. Then what is the option available to such operational creditor? What is the option available? He has supplied goods, but there is a dispute. Now the corporate debtor is not paying. He cannot initiate IBC. What is the option available to such operational creditor? Where
Go
he
to
will
court?
Yes,
Go to court?
Court.
he will go to courts. Otherwise, if as per the agreement, there is some arbitration mechanism,
Yes.
then he can avail that arbitration process.
Hmm.
Otherwise, he will go to civil courts, and there is a concept of commercial courts also. These days,
Yes.
there is a concept of commercial courts also. So he can go to commercial courts also, which are there in major cities like in Delhi, Bombay, etc. There is a concept of commercial courts also because civil courts are already burdened with so many other suits.
This is case of Kirusa Software and Mobilox Solutions.
Yes, very correct, very correct. So what were the key features of this BLRC? As some of the points we have already discussed. So there is a distinction between financial creditors and operational creditors. Different type of financial creditors we have already seen. There could be consortium finance, there could be individual financing, and in case of operational creditors, we have seen that there are different types of operational creditors like suppliers of raw materials and goods, government authorities, etc., etc. So it treats both the secured and unsecured financial creditors at par for the purpose of initiating an IRP and providing an opportunity to participate in the decision-making process. Suppose an individual has given a loan to a company and there is a dispute whether he can trigger this insolvency resolution process. An individual has given a loan to a company. The default amount is more than 1 crore. Whether he can trigger this insolvency resolution process or not.
Yes, sir, he can.
As operational creditor.
No,
He's
no,
a
no.
financial creditor.
He's a financial creditor. He has given loan, but there is a dispute.
As a
If there is
financial creditor,
dispute, he can't.
He can.
he can. Because he's a financial creditor.
There is no, yes. So there is a distinction here between a financial creditor and operational creditor. Financial creditor can initiate CIRP despite a dispute. The adjudicating authority will not look into the dispute thing. They will only ensure two things. Number one, there is a default, and second, application is complete. That is the only thing. So there is no question because the financial creditor, the corporate debtor will always dispute that this amount is not payable. So adjudicating authority, they will look into that matter. If is there could be a dispute because of so many things. But in case of financial creditors, adjudicating authorities look at only two things. Number one, there is a default and application is complete. But in case of operational creditors, if there is a dispute, and dispute could be either of the things. Suppose some arbitration case is going on. So in that case of arbitration, the adjudicating authorities will not admit the application. But if there is an arbitration case going on between the financial creditor and the corporate debtor, then they will admit the application. If there is a surface proceedings which is going on between the financial creditor and corporate debtor, they will admit. So these are the things. So distinction between financial creditor and operational creditors. So they will treat both the secured and unsecured at par. Empower an operational creditor to trigger an IRP but not participate in the decision making, since such operational creditors would be paid the liquidation value at the least. This we have already covered. Detect distress as soon as possible and resolve it. IRP can be triggered by the occurrence of a single default. Creditor in control. This concept we have already discussed, as opposed to the old debtor in control system based on the UK law. There is a concept of moratorium to protect assets while they negotiate and assess the viability of the entity. Now let us briefly discuss this last concept of moratorium. What is this concept of moratorium? So I'll give you an example to understand this concept of moratorium. The company is being run from rented premises. The company is being run from rented premises. They are not paying the rent to the landlord. Now there is a default and the company has gone in for CIRP. So whether the landlord can ask the company to vacate the premises or not. CIRP application has been admitted.
So the creditor will become the operational creditor. The landlord will become the operational creditor, and he will get the money from from the board now, from the insolvent professionals.
No, my point is that actually the company is being run from rented premises.
But they cannot ask him to vacate it as of now,
Yes.
because the assets have to be secured.
Yes. And he is not paying the rent also. Then what is the recourse available to the landlord?
He will get it from the insolvency matlab, the scheme, whatever will be finalized. From there, he will be getting the rent.
नहीं वो तो ठीक है. But if we go to section 53, where he will fit in?
Other
There are two
creditor.
parts, sir.
Operational
One will
creditor.
be the rent till the date the CIRP process was started, and another will be the rent for the current period. The rent for the previous period will go as a debt, as a operational creditor, and the current rent need to be paid by the IRP or RP on the basis of on priority basis, like the cost of.
Very correct. Very correct. Because section 40, I would like to draw your attention to section 14(1)(d). Section 14(1)(d) says if there is any party whose interests are prejudicially affected because of moratorium. So this landlord is the person whose interests have been prejudicially affected because of the moratorium. Then he will pay it as part of the insolvency resolution process cost. Because he cannot say take him to court. This landlord cannot take the tenant, which is the company, which is into CIRP, into court. He cannot ask him to vacate the premises also. So naturally, his rights are being prejudicially affected. So in that case, he will be paid in priority. So he will be paid as part of the insolvency resolution process cost. So if we see the definition of insolvency resolution process cost, it covers an item. Suppose somebody's interests are prejudicially affected. So then it will become part of the insolvency resolution process cost. So the dues which are during the insolvency resolution process period, they have to be paid in priority. So this IBC is fair to all. It is fair to the financial creditors. It is fair to the operational creditors. It is fair to those whose interests are prejudicially affected. Now the last point. What is the basic distinction between the secured creditors and unsecured creditors? Whether they are treated at par or whether they are different in
The
IBC.
the secured creditors are not the part of insolvency process, sir?
No, sir, they're treated at par, I guess.
No, they are a part. So the first question, if we ask whether secured creditors, they will enter the COC, the answer is yes.
Yes.
They will become a committee member. But they cannot initiate, they cannot enforce their security during CIRP period. Suppose there is a person who has given a loan to the company and he has created a charge on the assets. So that charge cannot be enforced. So any action under SARFAESI cannot be taken during CIRP period. But whether any action can be taken during liquidation period?
No, sir.
Yes, the answer is yes. If I would like to ask you to read, I would like you to read section 33, subsection 5. Section 33, subsection 5 says, whenever there is a liquidation order, it is subject to section 52. And section 52 talks of rights of the secured creditor. So during liquidation, any action under SARFAESI can be taken.
Okay.
But that is not possible during CIRP. So CIRP is something similar to a person sitting in a hospital, a person admitted to the hospital. So a person who is admitted to the hospital, doctors will not allow anybody to disturb him. Doctor is something similar to IRP or RP. But whether that person who is sitting in the hospital, whether he can disturb others, the answer is yes. So if a company which is into CIRP, that company can initiate CIRP against another company. Suppose XYZ Limited is into CIRP. An application has been admitted against XYZ Limited. But XYZ has to take some money from say ABC Limited. So whether XYZ Limited can initiate CIRP against ABC Limited, the answer is yes. But now this ABC Limited, whether it can initiate any proceeding against XYZ Limited who is into CIRP, the answer is no. They have to file the claim. So once CIRP application has been admitted, nobody is allowed to disturb that company. He is something similar to a patient admitted in a hospital. So let that process be handled by the IRP or RP. Let the committee of creditors decide. Let them decide on their claims. Because it's a time bound period only. So it's a matter of time only. After that time is over, they can take any action. Suppose the CIRP period is over, then the secured creditors can take action. But during CIRP, they will not be allowed to disturb. So no action under SARFAESI, no action under any court proceeding, nothing. You can take action against the directors because directors are different from the company. But you cannot take action against the company. This is the difference. Last question. Electricity dues have not been paid by the company. Whether electricity department can disconnect the electricity supply or not.
No,
No, sir.
during
No.
moratorium
No.
period, no.
No, because
Yes.
it comes under essential services.
Yes.
So there are different types of services which are covered under section 14, essential services, then critical inputs. Regarding critical inputs, they have to pay the current dues, but for the period before the insolvency commencement date, they have to claim it through claim form. But essential supplies like drinking water, electricity, telecommunication, so these cannot be disconnected even if the company does not pay. So we will end the session here. So this was a brief introduction about IBC. I would like you to please watch this video during daytime also, or prior to attending the second session, which is scheduled for tomorrow, so that you can get a overview, because some of you joined late. Well, I'll share with you the PPT also, and thank you so much for attending this session.
Thank you, sir.
And this
Thank you, sir.
this will be available to you in the group. So I'll post this recording also in the group.
Thank you, sir.
Thank you.
Thank you.
Thank you,
So,
sir.
Veeraji, I hope you enjoyed the session.
Yeah, yeah, definitely, sir. Definitely.
Okay. And during daytime also, you can ask me any question,
Okay,
either
sir.
through an audio note, or you can call me also. You can send me a message on WhatsApp also. Whatever are your queries, not only limited to this section, but to the entire course. Anything you need.
Sir, what was this old debtor method of this dissolution or anything? Like there's this thing now, we are working on this creditor method now.
Yes.
So what was the
Actually,
old method?
the old method that I told you, there are two laws. One is US law, another is the UK law. US law allows the debtor to stay in control. They allow the existing management to stay in control. Like you might have
Okay, okay.
observed, prior to this IBC, management used to stay in control.
Okay, I got it, sir. I got it.
Ah.
The management is the debtor.
Yes,
What
yes,
is over
yes,
there.
yes,
Okay.
yes.
Thank you,
In
sir.
case of pre-pack also, now also, they are allowing the management to stay in control in case of corporate MSMEs.
Corporate MS.
Unless they are playing a fraud. In case of fraud, so there is a shift of control in PPI-RP also, but otherwise they allow the existing management to stay in control in case of CIRP of corporate MSMEs.
Corporate MS.
And that is called the pre-pack insolvency resolution process. Thank you so much.
Thank you, sir. Thank you.
Thank you, sir.
Thank you.